Folks, we're back. This is Steve Sampson, Stephanie Phillips with another episode of Veterans in Politics. Today we have Gregory Gordon, Clark County District Court Judge, Department C for cat. But before we get to Judge Gordon, Ms. Phillips.
Thanks, everybody, for joining us. And thanks to our sponsors. We have Simplify Heating and Cooling. It's hot out there, so if you need your system checked, get in touch with them. Their website is callsimplify.com, callsimplify.com. Also, we have Mayor Michelle Romero. She is Henderson's mayor, and she's running for re-election. Her website is votemichelleromero.com. votemichelleromero.com. Jump on there and see what she is all about. And also, we have Board of Regents candidate for District 3, Angelo Carvalho. His website is carvalho4nevada.com, and that's the number 4, carvalho4nevada.com. Jump on there and see what his platform is about. If you are a candidate or have a business or a nonprofit and you would like to advertise with us, get in touch with us. And candidates, if you're the first to advertise with us and we have room on our wall still, we will not advertise your opponents. So get in touch with us on that. We also have a merch store, vipimerch.com, vipimerch.com. Check out what we have on there. Lots of fun stuff for you. Also, grab your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a litigant in family court and you don't have an attorney and can't afford one, this is a self-help book and you can get it on Amazon. It is $14.99 and he'll even autograph it for you. So grab that. And also we're planning our ball. It's February 7th of 2026. And we're going to be putting on some extra early bird tickets this summer. They're going to go on sale July 1st. And there's only so many of those really early ones to go around. So you're going to save a lot of money. You're going to want to grab those early. So for my rant, guys, and last show, I was in a hurry because I've been told to make my rants shorter. So I was talking really fast and I forgot to look at my last note, but it was about the parade in DC and how the media was talking about how much money of taxpayer dollars was spent for this parade. However, they forget to mention that out of that money, it was largely funded by a lot of donors, such as America 250 Foundation, Oracle, Lockheed Martin, Palantir, sorry if I mispronounced that, Amazon, and Coinbase. So that wasn't all taxpayer money. In fact, most of it was donated. So okay, now to my other rant.
Uh-oh.
Sorry, my 2 minutes gets to start over. So we've been seeing these riots, protests, No Kings riots, and these people are protesting and rioting basically because they think Trump is a king and a dictator and they don't like him. But, you know, talking about kings and dictators, you guys didn't riot and burn the place down when they shut our country down for COVID, when they forced your kids to stay home and they closed schools and churches and you couldn't worship and you had to put a mask on your face and you had to put a mask on your kid. And then, in order to keep your job, you had to have a jab in your arm that was an experimental drug, not a fully tested vaccine. You had to stay 6 feet apart. You couldn't be around your loved ones in the nursing home because when they were dying. And there was mandates everywhere. And you guys want to talk about kings and dictators? I'm sorry. So what you guys are saying when you're rioting against ICE for what they're doing, and the president is directing them to get rid of illegal aliens that are in our country because they're criminals. They came here illegally. They are getting rid of a lot of fentanyl and drugs off the streets, hundreds and hundreds of pounds, tons and tons of drugs. They are rescuing trafficked children. They are finding these children and they are arresting traffickers in these raids. So when you guys, when the people out there are rioting and they're against this is what they're standing against. So think about which side of the law you're on. Think about these poor children that they're finding. And you know how many young people die of fentanyl overdoses in our country? thousands and thousands of them every year. So they're taking this off the streets. They're doing good things. So I would say these people need to get over their Trump issues and look at what's really happening, because this is good for our community and this is good for our country. We're getting rid of these criminals.
Are you done, Ms. Fuller?
Yes.
Judge Gordon,
Yes.
thank you so much for being on the program.
Thank you for inviting me.
Could you give us a bio, please?
Sure. I was born here in Las Vegas, grew up,
Woo!
product of the Clark County School District.
Wow.
The, just typical childhood, grew up over by Sunset Park. Back then, that was the very edge of town. Town didn't go any further than
Right.
Sunset and Pecos.
Mm-hmm.
Went to Valley High School.
Okay.
Graduated there in 1987. Went off to college in Los Angeles. I was a first-generation college student. My parents didn't graduate from college. Went off when I was 17 to tackle that.
Get your JD too.
Got my JD at Pepperdine right after college. Went to that campus, visited it in Malibu. I don't know if you've ever been there.
Mm-hmm.
Dean's Honor Roll.
I was on the Dean's Honor Roll. But when I saw that campus in Malibu, I said, where do I sign up? And I did. Enjoyed my time at Pepperdine. And then when I graduated from law school, I came back to Las Vegas, joined what then was a relatively large law firm for Las Vegas, in Las Vegas terms, Jolly, Erga, Worth, and Woodbury. It was a general civil litigation firm. They had a family law practice as well, several partners.
You made partner.
I did make partner there, was there for a total of 10 years. Back in that day, that's how lawyers learned their craft, right? It was a sort of a traditional mentorship. There were, older attorneys of a different generation who would teach you the law. You would practice in different areas. And you would learn how to be a lawyer. Something that was so important to me then was what was instilled in me was the ideas of integrity and what you say in court matters, right? Every time you speak in front of a judge, you need to know what you're saying is true. You need to know the law, know the cases that were cited in that brief, know the cases that were cited in the other side's brief. Because every time you spoke in front of a judge, it was your integrity that was on the line, as well as the firm's. And imagine as a young lawyer feeling the weight of that. And I spent 10 years learning from some amazing lawyers, and learning the craft of how to be an advocate and how to be a lawyer, and just learning a love of the law. It's different than I think it is today, the way so many lawyers come out of law school and just, put up a shingle and.
But you've been active. You were with the Nevada State Bar.
I'm a member of the State Bar, yes.
Clark County Bar
Yes.
Association, the American Bar Association.
Yes.
You even a reporter for Family Law in the Nevada Lawyers Magazine.
So I've published.
You were a reporter?
Well, I've to some extent.
What did you report about family law?
To some extent, I've published a lot of articles over the years on various different topics. The most recent articles that I've written in the last couple of years since becoming a judge, which I think probably would be of interest to you and a lot of your subscribers and followers, is addressing how many self-represented litigants we have in family court. When I took the bench, I was shocked by the number of cases.
65, they say.
I think it's higher. We don't have official numbers, but I think the number is closer to 75.
Wow.
So I wrote an article about that from the judge's perspective. And then one of the big things that I helped to implement.
Sell my book from the bench.
We need to put a stack of these in every courtroom.
Well, what I want to talk to you about, because I haven't heard you sort of chime in on it, is so when I realized that we have so many self-represented litigants, and these are individuals that have real problems, right? I mean, kids are being raised in this conflict, right? Mm-hmm. And when they can't access the court system, it's the kids that suffer. We need them to get into court and for judges to help try to, untangle what is causing the problem. And when we send them away because the right motion wasn't filed or this T wasn't crossed or that I wasn't dotted, then, we're just sort of delaying these issues. So what I did was I said, we need to address this. We need to make the system more accessible. And the way that I approached it was we need to address trials, because trials are the toughest aspect of the case for self-represented litigants, right? They can find forms, they can file forms, they can get through a hearing with the judge, a 10-minute or 15-minute hearing. But if the case has to go to a trial, and there's rules of evidence, and there's rules of procedure, and there's local rules of procedure, how can they possibly understand all this?
Subpoena witnesses.
So many times individuals come in, they haven't even prepared anything, right? And as a judge, I'm supposed to be neutral. I'm not supposed to take sides. I'm not supposed to be driving the presentation
Or give legal advice.
But if I don't hear evidence and the information I need, how do I make the right decision for that child?
Right.
So what I adopted, and it's being done in some other states, is what we call informal family law trials. And I don't know if you've heard of this, but so we looked at Oregon, for example. Oregon's been doing this since 2012. I wrote the set of rules for Nevada, 3 pages. So you're going to go do a trial in family court, divorce case, child custody case. I hand you those 3 pages of rules. These are all the rules you need to know. You don't need to know anything else. Imagine what that does to a person who has been feeling so lost and overwhelmed by this process.
Feel relief.
Now I can read the rules.
Got a guide.
I can understand what's expected of me and what's going to happen. I don't leave court that day thinking, what just happened? Why did the judge sustain every one of those attorneys' objections and none of mine got sustained, right? Why did the judge let that person speak, but not that person? When you read these rules, 3 pages, every pro se litigant is on an equal footing. Does that make sense?
Yeah.
And I think when I first approached and I thought, we've got to fix this, we've got to do something, I thought it's because judges we can't just make it up as we go, right? But we can't use the traditional system because it doesn't fit with pro se litigants. In other words, there's no opening statement and then they present testimony. That's not how a self-represented litigant works. There's no question and answer format because there's no one to ask the person a question.
Some of us could do that and don't have a license to practice law.
So what we fixed those problems, and what I realized in fixing those problems from the judge's perspective is what we were actually doing was creating such value for litigants, because now imagine how much better they feel about the process. And that means everything, because we have to not only do our job, but the most important thing is for people to feel like it was a fair process, right? That's sometimes just as important as the decision itself.
Judge Gordon, isn't mediation mandatory?
So mediation is required in all custody cases. And that's been the case for a long time.
Some judges don't do that though.
No, I mean, it's a requirement under the rules. And so all judges respect that. And I think it's so critical. And let me tell you why. Okay. I try to empower parents as much as possible to resolve these issues on their own. And mediation is what they do right out of the gate. In other words, as soon as the case is filed and the answer is filed by the other side, in my court, they're sent to mediation. And they're given the first chance to try to work it out as parents before I put my hands on the case.
And you won't change it if they agree.
And I won't change it if they agree.
Some judges do change it.
I mean,
I've seen it.
The case law requires that we respect the agreements of parties and parents as long as it doesn't violate public policy, right? I can't recall a situation where I overruled what the parents have agreed. Sometimes they'll come in and they'll say, well, we agreed to just be reasonable and dad can see the child when he wants. Right. Now, the law requires there be some specificity.
Right.
And so I will ask them, that's fantastic, but can we put some more substance behind that? So I may help try to flesh things out, right? Sometimes the agreements come back from mediation and they may have some confusing provisions or they just may need some clarification. But what I love is giving them the chance and empowering them to try to work it on their own. And the reason is because they may be fighting over where the child's going to go to kindergarten today. And if they come into court and expect me to settle that dispute, what's going to happen when the child finishes 5th grade and needs to go to middle school? Are we going to fight about that? Are we going to fight about should the child be in soccer or baseball? If they rely on me as a crutch to settle every dispute they have as parents, when does that end? So I try to get parents to, see the value in compromise, to see the importance of getting off on a good start by coming up with some agreements on their own.
There was sorry, Ms. Phillips, there was Nevada revised statute that says that, it escapes me right now, that you have 6 months to finish your case. Is that accurate?
It's a Supreme Court Rule, Court Rule 251. Okay. And what it says is that custody cases should be resolved by the court within 6 months.
And why some taking 17 years?
unless there's exceptional circumstances.
Like, what are those?
Yeah, like.
Well, let me say two things.
Wrong colored socks.
I think this is a great point. I think this is a great point that you bring up, because actually there was, and I've talked about this with some of my colleagues recently, there was a Court of Appeals decision that just came back in the last week or two, where a judge up north, the Court of Appeals issued a writ against a judge up north because the case, let's just say, came in, I don't know, March or April, and the parties agreed to do a settlement conference closer to the end of this year. Okay. And the court said that they issued a writ telling that judge, no, you have a duty to resolve this case in 6 months. So the appellate courts are serious about that Supreme Court rule. And I think it's a great rule because, let me tell you, custody cases need to get resolved, right? The longer these cases, we've known this.
So you can move on with your life. Because some litigants are just stuck.
They are
they go
stuck.
on for years.
And this is where, so as a practitioner, before I took the bench for 30 years, I saw firsthand clients that were in the worst of predicaments, who saw no hope for what life would be like after the end of their marriage or after this divorce. And countless stories I can tell you where a year or two later, it had all just turned around for them. Yes. You know what I'm saying? And it's time and it's closure and it's the ability to turn the page. Yes. And what I love about being a judge, what I'm so passionate about, is getting litigants to that place where they can maybe close that chapter.
And they gotta learn how to compromise. Some of them just don't know what that word means.
They don't. And some need to hear from me sort of a little bit. Sometimes they need to hear, I need to put the other party's words, like sometimes they hear it from me and that helps, right? Like sometimes I'll talk to dads and I'll explain the reason why mom filed this motion is she's frustrated because you're not coming around as often as you should, right? Mm-hmm. And maybe she's not articulating that in a way that's constructive. Maybe he doesn't want to hear it from her, right? But she filed that motion for a reason. And it doesn't need a change in custody per se, but sometimes it's just a tap on the shoulder to say to dad or to mom, let's do better, right? She wouldn't have dragged you in here and put herself through this, because this is not a fun experience for anyone, right? This isn't like what she considers a fun day, right? But she did this because she felt like she had no choice. And sometimes just helping articulate what she's feeling to the other side can maybe get the point across. And I think what's so important from a judge's perspective and what I love doing is diagnosing the situation with the case and trying to understand, is this a case where maybe we do need to consider a change in custody? Maybe this schedule doesn't fit what these parents are capable. Maybe it doesn't match what this child needs. Or is this just a situation where we just need a strong lecture, a good talking to, and we just need to do a little better and hope that we can get up back on the right track? Because listen, we all are busy. The kids are going in a million different directions, right? It's easy for a parent, and when the parents aren't on the same page and they've been fighting for years, it's easy for them to just grow a little irritated with the other side and for parents sometimes to kind of let things slide. So sometimes being in court just helps kind of encourage people to all do a little better, you know?
It does.
But you got to identify what those cases are versus the cases that are like, no, this is going to require a little more involvement and a little more intervention.
Some people get panic attacks when they go to the courthouse. I've seen it. Sometimes it's really, really bad.
The reason why informal family law trials was so important to me is because I could see in people's faces the confusion, the sense of this is too overwhelming, right? I mean, I had a woman today who was she was getting emotional and, you know, we needed to take a moment because the moment was just too much for her, right? And I don't want her feeling like she didn't get her chance to say what she needed to say, right? Because that's so critical.
Right.
So, you know, you have to be able to read those situations and know, you know, when you got to take a pause and give someone a break, right?
Every judge over there should have that kind of compassion that you do, because we don't see a whole lot of that. But
well, I mean, listen, I work with some amazing individuals down there, and I don't think anybody signs up for this job and what this job requires without a real passion for wanting to help people and improve, you know, these people's lives, because I don't think anyone does it. There's no other reason to do this, right? I mean, there's no other ulterior purpose, because it's a tremendous amount of work. There's days when I leave the bench and I'm just emotionally spent because I've spent all morning really trying to get through to people. Like, what is the currency here that I can get through to these parents to stop fighting, to not have this child exposed to so much conflict, right? Because that's really what's damaging kids. I do. I have 3 grown kids.
You didn't mention that in your bio.
I didn't mention that in my bio. I have, my youngest is about to turn 20.
That's the baby.
Yeah, I have 2 boys, and then my daughter is the youngest.
Okay.
My kids are fantastic. I've got one who's
Grandbabies?
no grandbabies. Let's not rush that.
I got 2.
My oldest is in law school.
Beautiful.
Here at Boyd, and so he just finished his first year. Super proud of him. And then my middle one is a first responder. He's just finished paramedic school, and his next step is to hopefully get into one of the academies and to be a paramedic. When he was a teenager, he was like a lifeguard. And I knew when he would come home and he'd be so excited about.
He likes helping people.
He does. And I knew from that moment that was going to be his path in life. And then my daughter's in college. She just finished her sophomore year. And
what's the major?
Her major is strategic corporate communications.
She's going to make a lot of money.
It's all about the internet and social media. And that's her passion.
You're going to have to borrow from her.
She'll take good care of you when you get older.
Yes.
So how often do you seal a case, and why are they sealed?
Yeah. So
you don't like sealed cases.
Yeah. And I want you to know, because I want to clean up some misconception.
Sure.
I've never sealed a case because I wanted to seal the case. Right.
Do some judges just seal because they feel like it, or they're protecting their friends, or
I've seen it. I've seen it.
And I mean, all I can speak to is my practices, right?
Okay.
I mean, I have never sealed a case because I thought the case should be sealed. The only time I've ordered a seal is under a statute which is soon to be repealed, right? Under 125, 110, which, as you know, the governor did sign SB 432. And so,
explain how that works.
Not to upset Stephanie, but
explain how that works for 32.
Oh, so you've heard my rant, Judge.
Explain how 432
listen,
works.
let me say this.
The reason why I asked is because I have a whole YouTube channel on court cases.
Yeah. I mean, listen, this has been a big transition for family court. Let's be honest. I mean, the Falcone decision, right, which had not been addressed by the Supreme Court in Nevada regarding privacy and the sealing of cases in family court.
432 is going to go to the Supreme Court. You do know.
Well, I mean, well, let's put aside the criminal penalty side of it, right? Because I don't get involved in that. I'm not political. I don't know the legislative side of that.
Sorry, Judge. You know it's a Class C felony, right?
Class D, isn't it? It's a Class D in 432.
It's a
Class
C.
D.
See, and as a family court judge, I wouldn't even know.
Which is the same category as auto theft and fraud.
Right.
So you
Right.
talk about your family court case, you might as well you go steal a car.
Right. Well, I think what I also think what's not lost on many of us is, and what I appreciate from your voice and from Steve's voice, is it's always beneficial to shine a light on our institutions, right? I mean, and what I was saying is I've never sealed a case. I have no desire to escape or avoid accountability. Okay. And I know you may disagree a little bit with this, but every day as a family court judge, I am under immense scrutiny. I have 2 appellate courts looking over every order, not every order, but most of orders that are appealed, right? So I'm constantly concerned about am I committing an abuse of discretion? Because I don't want to do that.
Have you ever been reversed?
I haven't been reversed. I've been affirmed 4 times, haven't been reversed.
Oh,
but I want to follow the law, right? So it's not just because I don't want to get reversed. I want to follow the law, right? So I have the courts overseeing what I do, right? I have attorneys, practitioners, people file motions for reconsideration. I mean, they have rights as well. The Judicial Discipline Commission, whether you believe they do a good job or not, but they are prosecuting cases against judges. So that's
like who?
Yeah.
Michelle Fury.
Michelle. They're the biggest hypocrites in Nevada. Yeah. They're just
no jurisdiction for one judge, and then jurisdiction for the other judge.
And our opinions are not the opinions
no
of the judge.
Right. Thank you for saying that.
Yeah.
Thank you for saying that. And then of course I have to stand for election, right? And because I was appointed in 23, I had to be on the ballot in 24. And then I have to be on the ballot again in 26. Mm-hmm. So as a family court judge,
that's good. You get to go out with the public. You get to see the public.
Not
like those federal judges. They don't need to do that.
Yeah. I mean, I don't enjoy the politics side of it or the campaigning side of it. Right. I do lean into the idea of getting out in the community. And that's why I appreciated being invited on this show. And I'm not afraid I'm passionate about what I do and about our court. And so I'm happy to get out into the community and talk about it as much as I can. So I get frustrated when, and I realize your job is to, shine a light on some cases that maybe you feel are going in the wrong direction, or people that feel like they weren't treated fairly and so forth. But from my perspective, there's no star chamber. Everything I do is out in the open, and I'm constantly being scrutinized for every decision I make. But I don't seal cases, to answer your question, unless people ask. And that's all going to change.
They just got to ask.
And what are those reasons? Like, what is the threshold there?
Let me give you an example of something and we'll have to see how this new law is applied in practice.
I need your interpretation of this before.
Well, let me give you an example. Let me ask you this question because, there's high profile cases, right? We know what those high profile cases are. And I understand why there may be some public.
Let me just stop you right there for a quick second. Sure. Even Governor Jim Gibbons couldn't have his case sealed.
Right.
with Dawn Gibbons.
Right. But let me ask you.
Heard of that, right?
Yes. I remember. But so let me. I mean, listen. I don't know. The Supreme Court has identified, and then get in their decisions some possibilities. Right. They've referenced the mental health of children as a possible state interest that courts should look to protect. That's what's been identified so far in the decisions that we have from the Nevada Supreme Court. Okay. 432, again, putting aside the penalty aspect of it, if you read the beginning part of the statute, it lays out the framework for what it would take to seal a case. Again, the law hasn't taken effect yet. It doesn't take effect till October 1st.
Which I thought was quick, because usually January sometime.
Yeah, we only have so much time to talk about these things in public. My goodness.
Yeah.
We'll be in the clink.
Would you bail me out, Judge?
But it's not on the criminal side.
Yeah, not on the criminal side.
He can't help us.
You're on your own.
Sorry.
So, as you were saying about SB 432, your take.
So yeah, I mean, I think we'll have to see how it plays out. I mean, I completely understand the policy interest behind this. It's a public courthouse, right? And what's interesting is when I started practicing law, what they would do is they would open the doors at 9 a.m. and everybody would file into the courtroom. Now, back then you had to do prove-ups, so there were a lot more hearings even than there are today at 9 a.m. because the judge would do like a series of 10 prove-ups. But I learned about the judges and I learned how to practice because I would show up an hour early because I was always so afraid of being late for court, right? So I'd always show up a half an hour early and I'd sit in the courtroom and I'd watch the judge preside over 3 or 4 cases before mine.
You're like, oh my God.
Well, I would learn, okay, that's how Judge Hardcastle deals with child support, or that's how Judge Marin would approach his custody.
Oh, we going back some.
I was there in.
It's been around a while.
We going back to Marin.
There were 5 judges when I started practicing. 5 family court
And now
judges.
look at you. There's a whole bunch of you.
A to Z.
Yeah.
A to Z.
Every alphabet in the
26.
book. I still didn't.
But that's how I learned. But that's how I learned, by being in the courtroom and watching the other cases. So I see the value in that. I get that.
I still didn't hear your interpretation of SB 432.
Well,
How do you interpret that?
well,
Well, how does that look like? Describe if nobody.
it's no different than the Falcone decision. I don't think.
Just describe it to our
Other
audience.
than the penalties.
Just describe it to the audience. How would you describe it? SB 432.
Well, what it starts with the premise that family court, like all courts, are presumptively open proceedings.
Okay.
And to seal a case, you have to go through, you have to establish that there's a compelling state interest.
What does that look like?
Well, I mean, I think there's concern about, hey, if this case is splashed all over YouTube, right? And teenagers are on YouTube, right? Then is there concern that, the child's friends are going to see what's happening in the parent's case, or see that the child, that what's being addressed in court is that the child's is having some mental health issues, maybe has been hospitalized, right?
I get it.
And so there's reasons why you don't want that splashed on the internet and for all of, do you want your neighbors reading about that? Do you want the child's friends reading about that? Mm-hmm. Does that make sense?
I get it.
So I think they're, but on the other hand, listen, we've got 3,000 kids in foster care in the child welfare system right now. Do we have enough resources to address all of that?
That's a lot of kids.
Do we have enough? Is the state, is the county, are we putting enough resources to help these kids? Listen, media attention, public scrutiny of what's happening in those cases. It's been proven through studies that in jurisdictions where there is more public access in those cases, that their children's success improves because the media is reporting about what's going on in some of those cases, or in our welfare system in general, right? That can maybe only help improve outcomes for kids. So, like I said, this is like the transition for family court in a way. And with the passing of the law, which goes into effect in October, we'll see how judges apply it to the cases.
Doesn't this, the way I read it and interpret it, is that it gives them great latitude to just seal that case for whatever reason, and no video. The litigants can't even talk about the case publicly. They could not come on our show. So if we have a litigant that has CPS involved and they've taken their kids wrongfully or whatever the case is, right? We can't talk about that. We can't do this. We can't bring that to light.
Yeah.
Am I interpreting that correctly? That it seems way more broad now that a judge can just, oh yeah, we're going to seal this one.
I don't think it's certainly not more broad than it was previously. Okay. I think Falcone and now this law is designed to do the opposite. Because now, in order to, I don't even know that blanket sealing of cases is ever going to be warranted. because what the law now requires is not only do you have to demonstrate what that compelling what is that reason why you're even thinking about sealing portions of this case. So you got to jump through that hurdle first. And then if you can get past that hurdle, maybe it's a circumstance like I've described where a child's mental health or health situation or those concerns, then the court has to go through all these additional steps of, well, what am I sealing? And the court has to narrowly tailor that to only seal portions of the record or the hearing that pertain to that, right? And so maybe these aspects of the case they don't touch on that. And so the court now under this law can't seal those portions. So I don't think you're going to see blanket sealing of cases. I think you're going to see more redacting of certain things. I mean, listen, there's HIPAA laws also that have to be concerned about. There are federal regulations that affect CPS cases. You know, CPS records are often sealed, not necessarily because the judge wants them sealed, because it's by federal law.
Yeah.
And there's federal monies that are at stake, and we can't run afoul of those laws. And that's part of, like I said, take that up with Congress, right? Yeah. So there's a lot of thorny issues there that even isn't that have to be sort of ferreted through. But I definitely think, you know, like I said, I don't think the judges have much dog in the fight. I mean, judges, I don't know any judges that are sealing cases because they want it sealed. It's usually because someone's asking. There's a side that's advocating for that, right? And the judges were applying the law at the time. The law has now changed.
Well, a lot of attorneys want cases sealed because they don't want their bad behavior to be all over the internet. And they even admitted that to me. Yeah. Some attorneys have.
Yeah. And there's judges that are friends with attorneys who happen to be a family court litigant, and they get special treatment, and the case is sealed, so you can't know anything about it. You can't bring,
like Joe Scalia and Marshall Willett.
Yeah.
Prime example right there.
Keep in mind, Steve, there were 50,000 cases in family court filed last year in 2024. I mean, at any one time, I have 400 or 500 cases pending, and that's 26. Imagine that with 26 judges. You're talking about maybe a handful of cases over, maybe less than even that over a period of a decade. So I would just ask you, like, don't judge the court.
Don't judge a judge.
Well, no, don't
generalize.
No. But don't listen. Like I said, 50,000 cases were filed last year, and in 1 year, I dispose of 2,000 cases. I mean, it's a lot. It's a large volume, but and 99.9% of the time, the judges are getting it correct, and they are doing it right, and the people are leaving, and things are getting better. There's always going to be the situations.
There's always that 1%.
There always, of course.
That I mean, I'm a Marine, right? And I had to do things, and that 1% could cost you your life, and then after that, it's done. There is no turning back from it. When a judge makes a decision, it impacts your life immediately on a very personal level. Yes. That could affect generation and generations. Yeah. So that one, it should be. I mean, I'm not a perfectionist, but it should be zero error when it comes to custody and visitation and relocation and termination and all that stuff. It should be zero. I shouldn't have the luxury of saying, well, 99 of my cases are good to go, but that one could be devastating. That one could be a double homicide, murder, suicide, which a lot of these family court cases you read on the paper, they don't tell you who the judge is. I have to go find out. Yeah. But you know that a lot of them were in family court before they did the murder, suicide.
Well, and listen, and a lot of those situations, you know, it's hard to say. It's sometimes, you know, there's only so much that you can do too as a judge, right? I mean, when I'm on the bench, like, you know, like
what color is your robe?
I have a black robe, and I do have a dark blue robe because my family teases me because I am partial to blue. So, and I thought, well, maybe I'll try a dark blue.
What's your favorite amendment of the Constitution?
My favorite amendment, due process is what is, you know, even as a family court judge, due process is so important, right? And we talk about pro se litigants, right? And we talk about, I can't just kick a case out of court just because someone didn't dot the I and cross the T, because then that family's in crisis, right? But I also have to make sure that people have due process, right? You can't just show up to court and all of a sudden your kid's taken away and you didn't know about it. So you have to be able to know when something can be sort of overlooked, when sort of the process can be adjusted for these litigants, right? And when it's like, no, that's the wrong motion and I can't let you get away with that today because that's a due process issue. So you have to be able to recognize that. And that's so important, right? I mean, I get so many motions filed in my court and one side shows up.
Yeah.
And it's custody over, let's say a 10-year-old child. How can I make a decision when I only have one of the parents there? I mean, we actually get on the phone, because what I don't want to do is make an order and then the other side finds out about it. And guess what? Now they're going to file a motion and saying, or something like that. It's not going to just go away. It's going to come back. So let's get on the phone and let's find out where dad is and why he's not here in court. Maybe he didn't get the papers, right? We got to. You do look for proper service when you do these things. We do, but proper service after a case has already been decided. Let's say 2-3 years go by. Proper service is mailing to the last address on file for that litigant. So they just put the papers in the mail to that last address. Well, that person might have moved 4 times, and they're supposed to update the court, but do they? Yeah, right. No. But I don't want to make a decision and because someone's not present, right? So we got to find out why someone's not in court.
Do you enforce that Nevada revised statute that says 6 months, if you don't see your child within 6-month period, it would consider abandonment? Do you enforce that, or what's your take on that?
No, I mean, no. I'm in custody cases, right? The Nevada's public policy, which is well established, it's the first statute in Chapter 125C, is that children should have equal access to both of their parents, right? Children should have the right to love both parents.
Right.
And both parents should be sharing the responsibilities, whether it's financial, emotional, or otherwise, of raising their children, right? I am a firm believer that all children, as a premise, I should say, presumptively, children want to have both parents in their lives, right? They want to have the ability and the avenue to love both of their parents, right? So there's a lot of reasons why a parent may fall out of a child's life, right? It could be financial. There could be mental health issues. There could be substance abuse issues. Heck, it could be a deployment, right? There's a lot of reasons. Maybe they had to take a job out of state, to, help support themselves, right? There's a lot of reasons why that happens, right? And then maybe that parent sort of finds their way back, right? Mm-hmm. That child has that hole, right? That child is not thinking, well, mom disappeared, disappointed me, so good riddance. That's usually not a child's attitude or point of view, right? And if we don't get in there and try to repair that or fix that, that child's carrying that loss into adulthood. And that doesn't heal, right? So there's always a circumstance, there's always a situation, and sometimes you just have to find a way to help that parent and that child sort of reconnect, You
do follow the Sailor Soldiers Act, since you brought up deployment.
Yeah, okay. Absolutely. And what a fantastic statute, right? So that if you are deployed, then everything just sort of is frozen. And even though you're gone for a year or so, you come back and I mean, that's part of service.
And right? How do you look at service connected disability benefits? How do you?
Well,
because it's supposed to be exempt from everything.
The law is clear. I mean, the federal law governs that, and so
we had to go make a state law saying you can't use it for alimony.
Well, listen, and
nobody was following the federal law,
and because of Nellis and Creech, and we have so many fantastic service members here in our community, right? So this is something that does come up, quite a bit. And I see so many veterans, and I get to see I do see the financial disclosure forms, right? That's part of what I do. And so I can see the benefits and all that. And yeah, but the law is there and the judges follow the law, right?
I understand what the premise was when they talk about vexatious litigant. But on another token, when I look at vexatious litigant, I think that it's unconstitutional.
Yeah.
How do you feel about it?
Well,
that?
You mean it's unconstitutional to
Because
declare someone?
you tie your hands. You can't defend yourself.
Yeah.
You can't.
I don't think it's as common of an issue as you may think.
Okay.
I haven't declared anyone a vexatious litigant yet. I have. Well, I didn't mean it that way. I haven't done it. I haven't done it. The law says this. Like, I have litigants that file routinely in my court, right? They're dissatisfied with my rulings. They think things are changing. They think that there should be a different order for custody. That's not a vexatious litigant. Okay. A vexatious litigant by definition is someone who's filing just for the sole purpose of harassing the other side. That's different than, I don't like what this judge said and I want the judge to change his mind. Or something happened yesterday, again, and now I think custody should be changed. That's not vexatious, I don't believe, under the definition of what a vexatious litigant is. The ones that I've seen declared vexatious are those, and it's the few that are like filing federal lawsuits against 5 judges, congressmen, like
the TMPs of the world.
When you're filing lawsuits against everybody in town, and our
leave no stone unturned,
and our county and our state have to expend resources to defend all of these frivolous lawsuits. That's being done just to harass. Now you've crossed into that. But it's listen, I try to be as patient as I can with some of what I would call the routine or the repeat customers. It's tough because people don't want to spend, the other party doesn't want to spend all of this time in court. The other side doesn't want to keep having to file responses to all of these motions. But those are the exceptions.
You talked about a high caseload earlier, right? Do you work Fridays?
I do work Fridays.
When's your admin day?
So I purposefully have no calendar on Friday because I write most of my orders, right? Anytime I have a trial, I write that decision. And what you may not understand or what the public may not understand is if I hear a half a day trial, which is typical, I set most custody cases for a half a day, I'm writing a 35-page decision because I have to go through so many findings, so many factors that the law requires me to, it's not just, hey, I'm going to award custody to mom and deal with it.
You don't chat GPT for that.
No. So I'm writing decisions. I also write orders after every calendar. Like I may have 12 cases in the morning. Okay. Well, if 6 or 7 of those were pro se litigants, I'm drafting that order, right? I help them maybe settle their divorce case. I'm not going to wait for them to go try to figure out how to draft that decree. I draft that decree. So I'm probably writing, in a given week, if I have to write 2 trial decisions, and let's say I write another 10 orders, I'm writing like 100 pages a week.
Yeah.
And that's in addition to the calendar that I hear every day, right? Because I have a morning calendar and then I have afternoon trials.
Do you just do domestics or do you do...
It's domestics. It's child custody, divorce, adoptions.
Okay. You don't do the termination of parental rights.
We get the what we call private termination of parental rights, which means CPS is not involved.
Okay.
It's not, your child's not been taken, but mom is trying to terminate dad's parental rights. Right? Usually because, or usually a situation where one parent's been out of the picture for
abandonment. What I was talking about.
Yeah.
6 months.
Yeah. But it's.
But
they're not many cases. They're not many cases. Listen, children like I said, I mean, there may be a situation where maybe there's a step parent in the picture, and maybe it is time to kind of close that chapter on the biological parent. But in most situations, two parents are better than one, right?
True. Do you believe that one judge should have the power to terminate a parent's right to their children?
Yeah.
I mean, that's a big deal.
It is a big deal. Well, it's,
Or you think it should be a tribunal, or do you think there should be some jury boxes in family court, which there's no jury boxes?
There's no jury boxes. I don't know that you'd want a jury deciding that. I mean, some states do that, actually. In Texas, they have jury trials in divorce cases. Could you imagine?
How about a panel of 3?
Yeah, a tribunal of judges, 3 judges.
Well, keep in mind that, listen, the case law from the Nevada Supreme Court is terminating parental rights is akin to the civil death penalty. The case law makes it clear how draconian this measure is. Mm-hmm. And I don't think that's lost on family court judges. My colleagues take that very seriously. And in more cases than not, when those rights are being terminated in the private realm, not in the CPS realm, a lot of those decisions are getting reversed, right? So I try to counsel parents, like, discourage it, because
relocation to another country or across the country.
Relocation cases are the toughest cases.
It's almost like
the relocation
termination
cases,
in some cases.
Relocation cases are the toughest cases, I think, that we face, and that's because there's no room for compromise, right? If that parent feels like they have to go, maybe that job opportunity is too good to pass up. Maybe that new relationship they want to pursue is that person's life is in a different state. Then there's no compromising. Right?
Isn't there?
It's tough for kids, and it's hard on kids, and the other big issue we have also is think about how tough it is these days financially for people to survive. Right, young people, maybe they're working a job, maybe they're making $22 an hour. It's hard how do you afford an apartment in this town?
Yeah,
how do you afford to live? Right. And so what I'm seeing is, and you have, let's say you're a young person, you're 25 or even younger, mm-hmm. and you're not married, right? Because you had a baby together and you never got married, but you split up, and you're both young, and you have these not so great jobs, and you lose your apartment, or your car breaks down and you can't afford to live. So let's use dad as an example. He's got to go to California, where his family's from, right? Where grandma lives, and he can go live with grandma and and he's got family support, right? That's a relocation case. Mm-hmm. But it's not like, I just want to move to Texas because I like Texas better. This is out of necessity, right? Or maybe dad or mom feels like they have no place to stay in Las Vegas. Mm-hmm. Literally, they would be homeless. They have to go out of state to go live with their grandparents, let's say, and they've got a 1 or a 2-year-old or a 3-year-old child.
So what are the criteria for relocation?
We have a very detailed statute that talks about I think there's 10 or 11. Actually,
I thought it was only 3.
Well, there's 3 initial factors, but one of those factors is best interest of the child, and best interest is another 8 factors.
Gotcha.
So you have 3 factors. One of these branches off into best interest, which is more factors.
Education or hospital or some specialty doctor and financial. I thought that's how it.
No, but again, there's these 3 threshold factors that the person has to get through. It's good faith reason for going, right? It's best interest of the child, and then it's just an actual advantage. And then you get into the best interest. And then if you can get past all those factors, then there's a second set of factors. This is why the decisions are 40 pages, 50 pages long in a relocation case, which I'm sure the litigants look at and the eyes roll back in their head and think, how am I going to read Judge Gordon's 50-page decision? But if I don't go through all those factors and show my reasoning of how I got to my result, then the Court of Appeals is right there thinking I didn't. It's like a math class where you can't just write the answer down, right? You got to show all of the steps of the math problem.
You got anything else for Judge Gordon?
I do. So
You've been asking all the questions.
I know.
I've been looking at her. She didn't. give
No,
me one.
you didn't look at me once. So we have this discussion after the show. Look at me. So one thing that really burns my britches about judges and court orders, child support is a big thing. A court order to pay child support. How and why did these guys, whoever, guys, gals, get away for years and not pay child support when you know some of these are lawyers, some of these are doctors, they're making money, some are trying to hide money so they don't have to pay child support. You've got foster parents that are supposed to be notifying the parents of medical appointments being made, or they have to have contact with the parent on a certain, there's a whole bunch of court orders that you guys put into place, and you do it for a reason. Why on earth are these court orders not enforced? How come these people are not drugged down to court and put in jail and held in contempt? How come they are not forced to, even if they can't pay all of what's due? Some of these are years of back due child support. How come they are not enforced?
Well, I mean, listen, every case
Some of
is,
them.
well, I don't know why some of them aren't. I mean, we have the Clark County District Attorney's Office. You're familiar with their Family Support Division? I mean, they have, what an amazing service, right? So any person with a child support order, right, who's a payee or an obligee under that order, can take that down to the District Attorney's Office, open up a case with them, and the District Attorney's Office will enforce and prosecute that case on their behalf. And in that court is running, I think they're running 2 judges full time.
And what if they
and they're
don't?
putting people in jail? Because I
What if
see
they
the
don't?
orders. I see the orders.
Because some cases they don't. They don't. These
Well,
people get away for years. So it goes back to you guys.
I mean, they also have, I mean, listen, the district attorney actually has even somewhat, to some extent, remedies that I don't even have. Because the district attorney's office in that courtroom, they suspend your driver's license, right? They can take away your, any type of professional license, because that all has to be reported, garnish wages. They'll intercept tax refunds. I encourage obligees to go file that case with the DA's office, because I don't have the authority. I mean, I could order it, but they're actually intercepting tax refunds. They're actually taking driver's licenses away, and they do it. I mean, I just signed an order the other day. I saw where the person was, the judge said, well, you're going to go spend 15 days in jail unless you can come up with, I think it was $500 in the next 45 minutes before, I think, before the transport leaves for the jail, and the person
he came up with
the money, and that was down at the child support court. But that's what they do, that the one on Flamingo, but they do that routinely, and so I don't get too many cases with a lot of bad child support actors. I don't see those cases too often. I get appeals from the child support court. In other words, if you go in front of a hearing master down at the child support court and you don't like what that hearing master did, then you have the right to appeal that to the district court judge. But that's where most of that gets addressed. But
what are
right.
your powers when somebody continuously doesn't follow your orders? Can you hold them in contempt?
Yes.
Can you put them in jail?
Yes.
And when is that appropriate?
Well, I mean, it's appropriate when a person is disobeying intentionally a court order, right? So you have to distinguish that from the inability to pay, right? You have to distinguish when it's a person, we don't put people in jail for not paying their bills per se, but if you're disobeying a court order, in other words, if it's been established that you have the resources and the money, but you're disobeying that judge's order, then the court has the authority to order contempt. Typically in those situations, it's the threat of contempt that is the best remedy, right? It's the fear that you're going to go to jail that's intended to coerce that behavior, right? Once you impose that penalty, you've lost that incentivization, right? So a lot of times it's Judge Gaston. You remember Judge Gaston talking about the old judges? Judge Gaston was a longtime judge, one of the first 5. he would always tell people, next time I see you, bring your toothbrush. That was kind of how he conveyed, you need to start paying your child support, or, you know, we're going to have another discussion the next time I see you.
Judge Gordon, isn't a family court judge a civil judge?
Yes.
And I know they say, well, you know, it's civil contempt, but a jail cell doesn't know the difference between a civil contempt and a criminal contempt. Shouldn't that be referred over to
there's differences.
Peace?
There's differences in the law. If there's a purge clause included, which means person has an out, right? And there's an ability to pay something and get out from under that incarceration, then it's okay.
And
I mean,
isn't it a conflict?
Most of the time, it's a monetary sanction too. I mean, the only times that I've held someone in contempt is more typically when someone's withholding a child, right? Maybe someone's violating a court order. Some of the most egregious ones are the holidays, right? That mom's supposed to have Mother's Day and she didn't get her Mother's Day. Could you imagine? I mean, or Thanksgiving, right? But in those situations, it's a monetary sanction. You know, you may be sanctioned $500 because that other parent's she's not going to get that Mother's Day back.
Right.
Right.
Isn't it a conflict when a judge says, I'm going to hold you in contempt, and it's the same judge that's doing the contempt hearing?
Well,
where do you think you're going to go? Already going to
argue. You're going to argue the rules with me? You know the rules. You know the rules.
You have anything else for Judge Gordon? Well, Judge Gordon.
We'll let you off the
That's
hook.
it. All
yeah.
right.
Judge
Okay.
Gordon, we're gonna let
All right. I was ready to answer it all.
No, I wanted to hit 432 and those court orders. So
Yeah.
Mark is going to zoom in on you, and you have the final word. You could say, you know, come vote for me, or make sure you come to court and pay your child support, whatever you want to say, and your point of contact if you have a website or anything like that.
All right. Well, thank you so much for inviting me here today. Listen, I'm, as I said, I'm super passionate about family court, the job that I do, and I take it so seriously and try so very hard to do my best in every case, right? And to get it right. And I really appreciate the opportunity to come talk about our court, and to, you know, try to at least give my point of view on some of these issues that are controversial, right?
Mm-hmm.
That there are different points of view about. And it's so important as a judge and also as a person out in the community to hear some of these different points of view, right? And that makes, I think, the court better. And I think that's, at least I know I can speak for my colleagues. That is our desire. Our desire is to get it right, to make our courts more accessible, and to make our people proud of our court, right? That's what we're trying to do. We're trying to build back some integrity in our courts, which, as you both know, is struggling right now, right? Mm-hmm. I mean, people are losing faith in our government. People are losing faith in all branches of government, and the courts too, right? Mm-hmm. And so we're fighting that challenge. So, and your organization does such a fabulous job of shining a light on some of these issues, and also just talking about candidates, right? Because we have this system in Nevada where judges are elected, and it's a tough system, right?
Like
because, well, listen, it's hard to get information out there about candidates. I mean, you know what that's like because you're one of a few that are doing it, right? But the majority, 99% of people, when they go fill out that ballot, they don't know who those judge candidates are.
No, we get all kinds of calls.
You get all kinds of calls, but that's even just from a very few people out there. The majority of people don't know. So anything that we can do to help inform the public about candidates and about judges and those sort of things is sort of fantastic. So, like I said, just thank you for allowing me here. I'm all over social media. That's part of being an elected official.
Okay.
Oh, yeah.
That was one of your questions.
Oh, that's right. You have a CCW?
No.
Carry on the bench?
No.
No? Really? Okay.
I'm trying to solve problems, not cause more problems.
It's just defense, self-defense.
It's defense.
Yeah. Okay. Well, thank you so much.
Well, thank you so much, Judge, for being on the program. Yeah. Thank you, Ms. Phillips. Folks, that's Judge Gregory Gordon, Clark County District Court Judge, Department C. We hope that this show has been informative and help you with your family court case. And we're going to see a lot of judges. We've seen a lot of judges, and we're going to see a lot of judges this year to more and more inform you on all these judges that's going to be on the ballot in 2026. This is Steve Sampson, Stephanie Phillips of Veterans in Politics. Until next time.